bond as it stands right now. Archer wrote in a memorandum opposing the request for bail modification. This court should deny the bond modification for several reasons. First, the defendant is facing multiple serious pending charges, multiple F2s involving serious physical harm to her children, and thus is a flight risk and a potential risk to the victims in this case. Second, the defendant has filed a competency motion. Consequently, she is at personal risk until her competency is known. Third, the defendant has new serious felony charges that will be considered by the grand jury. Did you catch that last part? William Archer wrote that Elizabeth Ciders has new serious felony charges that will be considered by the grand jury. That sounds like those.
This court should deny the bond modification. Those 6 words appear on page 1 of a memorandum filed in Vinton County, Ohio, are signed by Prosecutor William Archer. They are directed at a woman who has not been convicted of anything. Her name is Elizabeth Ciders. She has been in jail since June 30th, and the state of Ohio has just told the court that what we know about this case is not even half of what is coming. Imagine a house with its curtains permanently drawn. You cannot see inside. You can only see the outline of shadows moving behind the fabric. Now imagine that house has existed in plain view for 18 years. That is the visual reality of this case. 16 children removed. 3 adults are still incarcerated. 1 grandfather was released because his medical bills alone could have bankrupted the poorest county in the state. The state of Ohio is not asking for temporary custody of these children. They are asking for permanent custody. That is not a legal detail. That is a declaration of war.
Elizabeth Ciders has been in jail since June 30th, going on 2 months now, and she wants out. Who wouldn't? Elizabeth's attorney has asked the judge to modify her bail, but the prosecutor has now responded in writing, and William Archer is essentially saying, not so fast, Judge. Keep her in. And his reasons for that are interesting, to say the very least. I'm going to go through all of this for you. Elizabeth's husband, Gary Ciders Jr., and her mother-in-law, Christina Ciders, are still in jail too. Christina Ciders' lawyer has also asked that she be released on bail. Gary Ciders Sr. is out of jail on a signature bond. The 73-year-old grandfather was released from jail because he has a serious medical condition. And since he was in jail, the county would have been responsible for his medical bills. And the prosecutor said those medical bills could have caused the county to go bankrupt. That's how poor Vinton County is. 1 inmate's medical bills could have sent the county.
Before we go deeper into what the documents actually show, make sure you are subscribed to the VerdictOrigin, because we don't just cover the story. We follow the evidence. Prosecutor William Archer wrote 3 reasons why Elizabeth Ciders should remain behind bars. Reason 1. She is facing multiple second-degree felonies involving serious physical harm to her children. Reason 2. Her own attorney filed a competency motion, which means the court must determine whether she is even fit to stand trial. Reason 3 is where the floor drops out. Archer wrote that Elizabeth Ciders has new serious felony charges that will be considered by the grand jury. Not charges that might be considered. Charges that will be considered. That is a prosecutor telling the public, without a single headline, that the 16 counts of child endangering are the beginning of the indictment, not the end.
There's also another little tidbit of information in here, very interesting and very important bit of information regarding Elizabeth Ciders. The prosecutor says that she's already facing these 16 charges of child endangering, and these are F2s. And that includes causing, basically serious harm to a child. It's neglect, not providing a safe environment, causing serious physical harm, things of that nature. But he's saying when this goes to grand jury, he's going to ask the grand jurors to indict her on new charges. So that makes me think this is in addition to those 16 child endangering charges. What does that say to you? Because I don't know what other charges. My mind is spinning. What other charges could Elizabeth Ciders face aside from child endangering?
Well, that was the most striking thing in the memo that the state filed opposing reduction in bond. And I think it's showing some cards to the public as well as to defense counsel that, look, you're looking at child endangering cases, but there's more coming and it's more serious. And that is also why she might try and flee. And that's also why she might try and reach her children to talk to them, to influence them one way or another in what their statements may be in relating to the endangering children, but any other offenses that may have occurred while they're locked in this small room for many years. The key to this, I think, is among other things, is it's long going. It wasn't just one discrete child endangering where a mother burned a child on the arm, and that's the basis for the single child endangering. This went on for years where they weren't sent to school, where they were locked up, that they weren't allowed out, that their life was very much restricted. All those things add up to an equation of a long standing neglect and abuse that.
And this is where the official narrative begins to crack. Elizabeth Ciders' attorney, Tommy Stolley, has said his client is not a victim. He said she does not consider herself a victim. But he also said he is still looking into that possibility. Let that sit for a moment. The defense is investigating whether the defendant is also a victim. The prosecution is saying, is she a flight risk and a potential risk to the children she wants to reunite with? Both things cannot be fully true at the same time. Someone is managing the story, and the story keeps shifting.
In the booking video of Elizabeth from June 30th, she was noticeably the only Ciders family member who wasn't handcuffed. Just looking at her, her body language appeared to be much different from her husband's and her in-laws. She cowered. Her shoulders were rounded, and she was practically hunched over. She seemed scared. This, coupled with how Elizabeth appeared in court and in her booking photo, and the fact that she had 18 children over about 18 years, made people wonder and question whether Elizabeth was the victim of something nefarious. When asked by a local TV station whether Elizabeth Ciders was a victim, her lawyer, Tommy Stolley, said Elizabeth didn't consider herself a victim, but he was still looking into that possibility.
Think about a pile of sand. Every time a lawyer speaks, they add 1 grain to the top. The pile looks stable. Then someone removes a single document from the bottom, and the whole structure collapses. That document is the competency evaluation. Judge Rogers has ordered it. It will determine whether Elizabeth Ciders has a mental illness that would make her not guilty by reason of insanity. That is not a formality. That is a tripwire. Because if the competency evaluation comes back and she is found competent, the state proceeds with everything it has. If she is not competent, the case changes entirely. But either way, the state is already signaling that it has more evidence than it has shown.
Judge Rogers has already ordered a competency evaluation for Elizabeth Ciders at the request of her lawyer. The evaluation will also include an evaluation to determine whether Elizabeth Ciders has a mental illness that would make her not guilty by reason of insanity. Tommy Stolley had said previously that Elizabeth Ciders wants to be released from jail so she can be reunited with her children, but that's...
Here is the hidden threat, buried in the prosecutor's language. Archer wrote that Elizabeth Ciders is a potential risk to the victims in this case. The victims are her own children, 16 children ranging from age 18 to 1.5, all in therapeutic foster care, all hidden from the public record. And the state is saying that if this woman is released, she might try to find them. Not that she has tried, that she might try. That is predictive language. That is the state saying it has information from inside the jail, from monitored phone calls, from something the public has not seen.
Yeah, good to see you. I'm really interested in your thoughts on this prosecutor, William Archer, coming out after all of these weeks and weeks after these requests for bail modifications were filed, and saying, We oppose any bail modification for these three reasons. And the first reason being, one of the three reasons he gave for Elizabeth Ciders, at least, was the fact that the issue of her competency has been raised. What do you make of that?
Well, I think first, in order to do a competency exam, the psychologists like to control the location and have it in a controlled setting. And if she was released on bond, too, there's no assurance that she would meet the examiner at the time and place identified. So examiners like to interview the suspect and give them any tests, psychological or otherwise, while they're in the county jail. If they're going to be released on bond later, that's up to the court. But I think they prefer that controlled atmosphere.
As things stand right now, we know what we know. We know that the 16 children were taken from the house on June 30th. We know that that three of the adults remain in jail. The children are in therapeutic foster care. This prosecutor knows a whole heck of a lot more than we do. He knows the inner workings of the investigation, what brought them there.
And this is where the case becomes a thriller. How many charges can one prosecutor file before he has to show the evidence? The grand jury convenes on a clock. 60 days from the time the case is bound over. That clock is already running. Before Labor Day, we will see the full indictment. The question is whether what is in that indictment matches what the defense is telling us, or whether it confirms what William Archer has been hinting at for weeks, that these children were not just neglected, they were hidden. And hiding children for years is not poverty, it is a system.
Well, I'm quite sure he's listening to any jail calls by her as well as the others. They're permitted to do that and have a big sign next to the jail telephone that the calls are monitored. Typically, they don't listen to phone calls between the
The phrase that matters is hidden children. That is what the prosecutor called them, the hidden children of Omar Street. He said it in a county commissioner's meeting. He repeated it in his filings, and now it sits at the center of everything. The children were not just unsupervised. They were not just removed from school. They were hidden from view, hidden from the state, hidden from anyone who might have intervened.
No.
I don't know what other charges she could be facing. I don't want to speculate here, but I think that, it goes without saying, the prosecutor's already publicly said, these children were hidden. I mean, he said that to the county commissioners in a meeting. They were the hidden children of Omer Street. He likes that a TV station calls them that. And the county is seeking permanent custody. There's not going to be any reunification. If the county is saying to the courts, we're seeking permanent custody of these children, I think that is signaling that this is incredibly serious and reunification is unlikely.
I think you're exactly correct. This case, ordinarily, this kind of case, even though this is a case of its own, exclusive kind, a case like this starts with a request for temporary custody to children's services, either on an emergency basis or otherwise. And then you do an investigation, you see what you have, and then you look at the family unit and look at relatives or others that the child might be placed at. But here they're starting off right from the get-go, seeking permanent custody, which again, as you say, says to everyone concerned that we don't think reunification with the parents of these children the way.
Elizabeth Ciders wants out of jail. Her attorney says she cannot post the $300,000 bond. She wants to be reunited with her children. She is asking the jail if she can send care packages to the kids. The state is asking for permanent custody. Those two realities cannot coexist. One of them is not telling the truth, and the grand jury is about to decide which one. Here is what you can do right now. Pull up the Vinton County Court of Common Pleas docket. Search for the memorandum filed by Prosecutor William Archer opposing the bond modification for Elizabeth Ciders. Read the third paragraph. Read the line about new serious felony charges. Then ask yourself one question in the comments. If the state already has the evidence for these new charges, why is it waiting for the grand jury to reveal them?
Victims, all this together, let's just keep her in jail until we see where we are. I'm interested to see how soon they may take it to the grand jury, because they typically have 60 days from the time it's bound over to the grand jury, and they've already consumed, probably a month maybe. In any event, they need to start getting the case together to present to the grand jury. And at that point, we will see what additional charges that have been waved around are included in the indictment.
Ron, you read my mind, because that was going to be my next question to you. When do you see this case going to grand jury? Because it's been quite a bit of time now. Is this a case where maybe they only want to go once? They don't want to have to go back to the grand jury, on a continuing basis?
I think that's exactly right. I think they want to have what they are going to proceed on included in the single indictment against all defendants, and include all counts against each individual defendant. And they have a clock, at least under the rules of superintendents, of 60 days from the time a case is bound over from municipal court to common pleas court. And in this case, they're probably close to 40 anyhow, and or more. And so at this point in time, I would think that it should go to the grand jury probably before Labor Day.
If this breakdown helped you see through the legal fog, like this video and share it. Subscribe to the VerdictOrigin and turn on notifications. The grand jury will meet before Labor Day. When that indictment drops, you will want to be here first.